Welcome to Rebel Chaser. My name is Gail, and I have several videos for you tonight. The first one is with Judge Boyd. She has a defendant who burned a word in his victim's front lawn, and he wants to get off probation early. I wonder how that's going to work out. The second video is with Judge Middleton. He's got a defendant who's very indignant that she is in jail. How dare he put her in jail? Anyway, I'll let you guys watch that. I don't want to give too much away there. The third one is a pretrial release failure. This woman was on pretrial release and she just hasn't been doing what she's supposed to do.
All right, so Robert Klein, who's on that?
Put him up here?
Yes. Yes,
Sure.
yes, we're here on this clock. He has a motion to revoke.
Yes, Your Honor. I can let counsel lead the way if you'd like, counsel, but I believe, especially while we're kind of off the record to begin with, this is their client's third MTR. And I know that counsel, again, if I don't want to miss anything, but I know you had previously put forth a motion to reduce bond, or I apologize, for early term.
Right.
So if you want to maybe just let the judge know what was maybe previously discussed.
Your Honor, would make clear to the state that the state had been given a CD with his medical records during the last 2 years. During those 2 years, he's amassed 1,200 pages of medical issues and problems. How many times have you been in the hospital for working with it?
8 times and about 15 surgeries.
15.
Yeah, and then I had a stroke. And
He also had a stroke that affected his physical capacity. Mr. Klein has tried very hard to live up to 100% of his requirements, and he's not been able to because of, I'd say 90% or more, because of his medical conditions. He lost his left foot in an accident, and he's now asking the court under his mercy, if there's not anything else, to let him stop the probation supervision. Robert, do you want me to swear him, Judge?
Oh, well, just a second. So I'll let you swear him in if you want to have him give testimony. It's my understanding that he does have the medical issues. The court is aware of your medical issues, but here's the court's problem. One, I'm not going to consider early term or anything without the complainant being present. Number two, in the stipulations, the allegations that were in it that were stipulated to was that he went to her father's home, burned the grass with, it says here, the complainant provided her statement to me, because I see you're curious about what I'm reading. The statement can be located in the case folder. In her statement, the complainant describes her relationship with the suspect and described his escalating behavior, which included burning her father's front yard with gasoline and spelling the word BITCH with said gasoline. She also reported how her vehicle was tampered with. The decision to obtain the warrant came after I returned the following week to work and received a message from the complainant that the suspect had went to her work and was observed placing tacks under the complainant's tires. I also obtained a statement from the complainant's boss. The complainant provided several case numbers which document suspect's behavior. So I'm not going to consider allowing him to early term until the complainant is here to express whether or not she has any objections to early termination. And I'm also not going to consider early term because I realize that there are medical issues that may have occurred. But according to the motion to enter adjudication of guilt, there's a non-reporting in September, October, and November 2023. There's the consuming of alcoholic beverages. I'm not taking any of this is true, but it's alleged. on March 9, 2023. On the 22nd of March, 2023, an invalid sample for drug testing. April 6, 2023, another invalid sample for drug testing. May 19, 2023, invalid sample. June 23rd, 2023, invalid sample. And then there's a number 5, not reporting July and August of 2023. And I know that maybe that's medical. 9A, not reporting a change of address, job, or arrest within 48 hours. Then there's number 23, failure to complete intensive outpatient drug and alcohol treatment. And number 24, violation of the zero tolerance. So I'm not inclined to grant an early termination if the complainant is not present by Zoom, if nobody objects to Zoom, to give some input to the court.
Well, and Your Honor, just to make clear, counsel and I have spoken, and I, of course, the state is sympathetic to, when things happen to people of a medical nature. But the state did let counsel know that given the frequency of the MTRs in and of themselves, I believe this is the third,
Yes.
and the term of probation is due before the end of the year. The state would kind of respectfully not be in agreement with counsel for an early term as well.
Okay. So the court is not going to consider an early termination without that information. What we can do is, if he wants to enter pleas to the motion to revoke, he can enter pleas today, or either we can set it for a contested hearing. And I realize that it may or may not be a contested hearing. We'll just set it for a contested hearing. That'll give a chance for parties to bring in whatever information you all want the court to consider.
I don't think I'm speaking out of turn. Would the court consider, I don't know if the statement from the state, if they would consider a termination unchecked, but you go on with medical care and stuff, it still does the work.
Now, I want to hear from the complainant. Yes.
What's the next one?
Oh, well, I'm sure the state has their contact information.
You want to give us a date there?
Yes. All right, if you all want, Norma, are we able to bring this back on the 22nd or either in March?
March 5th.
Oh, well, look, we're setting on the day he lost his leg and on the day of your daughters, your twins. All right, so March 5th?
Well, Judge, may I ask one clarification question?
Yes.
Sometimes, and of course, it's nothing to do with the party standing before you. In general terms, as the state, I may not give information, contact information, phone numbers of complainants, particularly those that have, been cooperative with the office in the past, and of course sought prosecution for the things that have happened to them. I'm more than happy, of course, to reach out to them. It's been a few years since we've had that contact. But if they indicate to me that same kind of willingness to cooperate and that same kind of almost happiness to kind of maybe not have anything to do with, the specific party, is it okay to relay that to counsel without sharing that information? Because I don't want to, I want to be as helpful as possible to the court and to counsel, but if she's still cooperative, I would maybe, I think, just be hesitant to relay any contact information over.
Oh, no, just have the person on March 5th. Defense, will you have any objection if they want to Zoom in?
I'm certain that Mr. Bryan has had no contact with the baby, will not, and I will not provide him any information or means by which he would help.
Oh, I know you would not.
And even if the state, Your Honor, is still if that complainant potentially, it's been so many years since we've spoken to her, but if they themselves have very strong thoughts on early term, and it may not be exactly what we anticipate, her testifying via Zoom or speaking to the court via Zoom is just add.
Just have her come in by Zoom and then we will see what she says.
What she said. Okay,
Yes.
Judge, thank you.
All right, you're
Appreciate it.
welcome.
And just for the record, trying to understand if you are not to have any kind of contact, direct or indirect, with police. Yes, you're not having that contact with her in any kind.
Month before I got, the one. We get over to you, almost.
Okay.
Thank you, Judge.
All right, you're welcome, Ms. Ferguson. Yes, Ms. Ferguson will give you a reset form that you can be excused. You're welcome. Thank you for coming down.
All right, this is a bench warrant arraignment in the matter of People versus Amanda Marion Jewell. Is that you?
Yes, it is.
I'm Judge
I'm just
Middleton. I'm here at the
Hi,
courthouse.
Mr. Middleton.
Your
I'm
attorney.
curious why I'm here today.
What's that?
I'm kind of curious why I'm here today. I was pretty sure I served my sentence out.
You never showed up for the
2022.
sentence.
I was pretty sure I was released to, and I served my entire sentence for the entire in 2022.
That might have been in front of Judge Stutzman, but
Nope,
in
it
this
was in front of
case,
you. It was in front
file
of you.
212545.
You were the judge in the case.
All right, well, in this case, you were charged with illegal entry.
And that
It
was
was
exactly
alleged
what it was for.
that you entered a residence at 8th
It
Street.
was a misdemeanor, correct?
Yes. And the matter was set for sentencing
I thought I'd already served my sentence.
on August 31st.
I thought that's when I got out,
Uh,
2022. I was here for like 60 days. I got picked up in July. I was released because the sentence was served, as far as I knew.
Whoever's in Amanda Jewell's case, will you get out of it? Well, let's go. You're mistaken. Let's go through the history of this. Ms. Casey Strong is here with us from the public defender staff. And I asked her to come in. All right, let's go back. On December 21st, you allegedly illegally entered a building at 11028.
What year?
12/22 of 21.
So in 2022, I was picked up and
All right.
served the rest of the
Just wait,
sentence.
just wait. I'm going through this.
Okay.
You got arrested and posted a bond in January of 2022.
Yep.
Attorney Timothy George was appointed to represent you, but he had a conflict, and the attorney then became Rhonda Ives. On July 13th of 2022, you got arrested for failing to appear, and you pled not guilty again. So I set the matter for an attorney pretrial for August 5th. Of 2022. You pled guilty to the charge on August 5th. So you trespassed on the house that Jamison Norman owned and allegedly trashed the place. You were in jail for 25 days. I gave you a PR bond and set the matter for sentencing for September 12th. Which you promptly never appeared again whatsoever. So your bluster this morning is wasted. You were in jail for 25 days. You entered a plea. I let you out of jail and you never showed up for the sentence. You never got sentenced.
I never got
What?
any notice to appear.
I told
when I
you in the
left.
courroven.
When
I may have
left,
even
I
given you
never got
something. I told you the matter was
physical-
set for sentencing on September 12th of 2022. I asked for victim input and a police report. Miss Norman was watching this house for her grandmother and contended that you or others trashed the place. So I set the matter for sentencing. I let you out of jail and you paid me back by never showing up again.
I don't remember ever getting a notice to appear
I
after when I
told
was
you in
released.
the courtroom what the day was
But
to
I
be
didn't have
here.
a physical, I physically did not have a sheet that said I needed to return to the court.
Well, we sent it to 1411 James Street, Kalamazoo, which is the address that you gave me in the courtroom.
Well,
That was mailed to that
sure
address
that
on
address
August
is no
31st.
longer, I cannot receive mail there. The house has been condemned.
So
I cannot receive-
on that day, your lawyer tried to call you several times, had no contact with you since you got out of jail. And the complainant was present and ready to give information about your case.
Well, the complainant was in the parking lot when I left the jail that day and threatened my life.
All right.
Norma
Well,
is her name?
no. Her name is
The
Jameson.
the woman that was watching the residence was in the parking lot that day when I left and threatened my life.
Okay. So
And I
anyway,
didn't have a
you
phone or
never called
anything
your
to
lawyer.
call, so
Your lawyer was unable to reach you and you never showed up. So how did you get arrested last night?
I didn't get arrested last night. I was arrested on Sunday
Where is that?
at 1411 James.
In Kalamazoo?
Yes,
So Sunday would have been February 10th, Super Bowl Sunday. How did you come to get arrested?
on my property.
Did they arrest you for something else or did they just find there was this
Yes.
warrant?
They arrested me for something else. This popped up
And
when
then
I
found this.
was going to be let out.
All right. What was the charge in Kalamazoo?
A false charge of controlled substance, dangerous drugs, and I'm supposedly on the FBI list. Who knows why, but
All right. So is that, and then they were gonna bond you out. They found this warrant in St. Joe County.
yep, this popped up.
All right. We need to get the case back on track. Monday's a holiday.
And I need to get out of here as fast as possible because I'm trying to get my taxes paid on my house so I can start renovations.
Okay.
Before the 1st of March, definitely.
All right, very good. I'll set this matter for sentence, and hopefully we can get Miss Ives here. The first day I have is February 21st.
And I have court in Kalamazoo on the 21st.
All right.
Do I have to stay in jail till, this matter goes to court? I would think that since it's a misdemeanor, I wouldn't have to stay in jail.
You're mistaken. I'm not very happy with you. You blew off your sentencing date. You never called your lawyer. The complainant came twice. You're trying to bluster me to tell me that you already got sentenced and did a bunch of jail time. I did you a favor by letting you out of jail, and you promptly responded by.
I thought I did. My mistake.
Okay.
I just want to get the matter resolved, and I don't want to miss being able to get my property taken care of before March. And I don't want to miss my other court dates in Kalamazoo.
Fair enough.
Trying to keep a better schedule. Only can do that if, we can work together. Because this is only a misdemeanor. Not that that makes it any less important.
There we go. Your lawyer is set to be here next Tuesday.
Have to be here till
February
Tuesday?
20. Yes.
Really?
We also need to give notice to the complaining witness.
So I can't get because now I have a way to get here. Before I didn't have a way to get here.
Yes.
I don't understand why I couldn't be released. If I do have a way to get here, I know I have a way to get here. Before I did not.
Well, you do now, because you have no bond. I'm going to deal with you on Tuesday, and I'm going to decide at that time whether to let you out on Tuesday or give you the balance of 93 days in jail. So you might want to work on your attitude a little bit. I'll have your lawyer, Rhonda Ives, here at that time. We'll have the complainant here. I'm going out of my way to set this as soon as I can on a date that your attorney is already scheduled to be here. Just because you're strenuous in your statement doesn't mean it's correct. The bottom line is, I let you out of jail. You blew me off. You never showed up. You never called your lawyer. Your lawyer couldn't call you. I told you the date in the courtroom. I mailed the notice to the address that you gave me. You've been AWOL for 2.5 years. So we'll deal with this on Tuesday. No, this is it. I'll see you Tuesday at 9 o'clock. All right. Ms. Strong, there wasn't much to say there, but that's the soonest day I can get Ms. Ives that she's scheduled to be here, which is next Tuesday. And we need to give notice to the prosecutor for the victim. She trashed this house, or somebody did.
People of the state of Michigan versus Amanda Shea Loncar, 4 files, 23, 69, 77, 78, 79, and 80 at a page. This is the people's motion to revoke bond. Ms. Loncar is in the courtroom represented by Attorney Stephen A. Barker. People are represented by Assistant Prosecuting Attorney Alexander Potty. Potty, you may proceed.
Thank you, Your Honor. This is the People's Emergency Motion. Back on January 30th, the people received a report from the pretrial services officer for the court, J.D. Wood, who indicated to the people that the defendant is in violation of her bond for failing to comply with the mandatory drug and alcohol testing as directed by the court, and allowing her GPS tether to shut down on January 26th of 2024. The people have submitted exhibits in support of those assertions, in that the defendant missed drug and alcohol testing, random testing on January 2nd, January 6th, January 7th, January 12th, January 17th, and January 20, and that the GPS tether went down on January 26th at 7:41 a.m. The people did file a supplementary amendment to this motion that indicates the tether returned to service I believe the following day, if not later that same day. Therefore, Your Honor, the defendant has failed to comply with the orders of this court and the requirements of her bond, and therefore we're asking for revocation.
Mr. Barker, any comment before we potentially proceed to hearing in this case?
Yes, Your Honor. Well, first of all, Ms. Loncar has agreed to my appearing by Zoom, so I thank the court for that courtesy, and we're prepared to go ahead. I've discussed the matter with Ms. Loncar. The facts, as alleged by the prosecution, are accurate. She does have explanation for what's going on. There was a period of illness with COVID for her and her grandmother, and there's been some financial constraints because once they were both sick, she wasn't able to work. And she's prepared to give the court the factual explanations, and having lived them, she can probably explain that to the court a little better than I can. As the actual details, but the gravamen of our argument is that as she's appeared today, she has not been any kind of a flight risk. She has not gotten in any other trouble, and she has complied well as she can under difficult circumstances. So if I can turn it over to Ms. Loncar for a moment, and she can explain to the court what led to the testing problems.
All right, let's place her under oath first. Please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes, ma'am.
Thank you. You may put your hand down. Actually, counsel, I'll allow you the opportunity to question your client.
Okay, Amanda, as you're aware, these dates that have been provided were actual dates that there were issues that you were not able to comply with, correct?
Yes, as far as I'm aware, yes.
Okay.
Mr. Barker.
Okay, can you explain to the court, bear with me just a second, here, we can find those dates. Okay, well, let's talk about the one date where the battery went low on the critically low and then shut off on the on your tether. What happened that day?
Okay, I speak to you.
You can speak to I can see.
Okay, that day, I wasn't even aware that happened, actually, Mr. Barker. I work third shift. I get off work at Taco Bell at 2 a.m. or 3 a.m., depending on the day. And I can only imagine I would have been sleeping at that time, and it sometimes comes unplugged while I'm sleeping, but I wasn't even aware of that until Jamie Woods just told me the other day.
So it did get turned back on though, so that would indicate that you apparently got it recharged and it came back up.
Yeah,
Yes.
within just, I mean, yes, Mr. Barker.
Within the same day. Now, on that day, you were where you were supposed to be. You either went to work or you were at home, correct?
Yes, Mr. Barker.
And there was no drinking involved or any drugs or any attempt to evade the surveillance of the
Absolutely not.
correct. Okay.
Correct.
Now, the tests that you missed, are
are all within a fairly short period of January 2nd through January 20th. Not quite 3 weeks. Was that the time that you were having the health issues with the household, you and your grandmother?
Yes, I care for my 80-year-old grandmother, and we had COVID for about 2.5, close to 3 weeks, and it completely demobilized us. It was the worst sickness that I've ever had in my life, and I wasn't even sure she was gonna come back from it, but she did. She quit smoking during that time, and she has to be on full oxygen now, but yes, that was during that time.
Okay, so you were not able to go and do the testing because of illness during that time period?
Cause, yeah, I could barely get out of bed, and when I could, it was to care for her.
Were
It was very difficult.
were you in contact with Jamie Wood while these things were going on?
Yes, Mr. Becker.
Did you keep her advised of why you had to miss these dates?
Yes, Mr. Becker.
Okay. Did she give you any directions or anything that you did not follow when you talked about this?
She told me to just make sure I get to my next ones. And
Now, from January 20th to now, have you had any, has there been any testing? Or did they suspend the testing?
I don't think the dates are correct on those. When was the first missed one, if you don't mind me asking?
The first missed one was January 2nd, the last one was January 20th. So January 20th to now is roughly 2 weeks.
Okay, yeah, we're familiar. Okay, I'm sorry.
Okay.
I'm exhausted. I gotta work at 2 and I haven't slept yet, so.
Has there been any testing from January 20th to now? Has your number come up where you?
No, but there wasn't any colors being called for several days in a row. Matter of fact, there wasn't colors being called for 7 days in a row at one point.
But you were calling in and checking?
Yeah, yes, of course.
Okay. If the court chooses not to, if this is merciful and chooses not to reincarcerate you at this point, will you comply strictly with all the requirements?
Yeah.
Okay.
Yes, absolutely. And I do have the money for it now, so.
Okay. So there was an economic issue also?
Yes, sir.
Okay. Explain to the court what your economic issue was. How much do you make and how much does this cost?
And I brought the proofs, Your Honor. And my pay stubs, I've only received 3 paychecks so far, and I was $700 behind on my father. Sorry, my mom was there. And so I had to make some payments for them, some pretty big ones. I have to pay for tell my grandma live at her trailer. But at this point, the colors weren't being called for 3 days, and the next day our battery completely died out, wouldn't start nothing. So I took the money I had. It was my only way to get to work, so my drops to anything that I needed to get to, Your Honor. So I had to use that money to get the battery. It was $199. And my grandma just said a little bit. So until I got paid again, I didn't have any money at all. My resources were just drained. I work in Freeland. I live in Coquitlam, so that's a 20-minute drive. And then I drop in Midland, which is another 20-minute drive. So I work till, if you don't mind me asking.
Wait, you said you live in Coquitlam?
Yes, Your Honor.
The address you've given the court is an address in See.
Yes, we changed that, I believe.
Who's we?
I spoke to Jamie Woods about it.
Is our waiver? Address of the defendant. All right, so you stated you've been in contact with Ms. Wood about all this?
Yes, Your Honor.
Amanda, would you give the court your current correct address, please?
Yes, sir. Are you right now?
What's your new address then?
2458 Paget, which is P-H-A-O-T Road, Coquitlam, Michigan, 48631.
Anything else, Mr. Barker?
Okay, Amanda, you are still currently employed right now, correct?
Yes, and I have proof of all of this. I've also had a couple different doctor's appointments because I had to reinstate my insurance to get back on my segments and stuff. Blood work, I got proof of those. And my grandma had to go get rechecked for her cancer, which is inside. I'm trying to draw there all the different areas that I have to go and do. And the funds just kind of ran out at that point. Right now, I'm set up where this will not happen again. Hopefully, there's an emergency, but even if there is, I have someone that I can borrow from.
So were you working between January 2nd and January 20th?
Yeah, yeah, I've been working for the last almost 3 months.
Well, how could you be working but not do testing? You said you were sick.
Yeah, no, I was off during that time. I was off during 2 weeks while I was sick, but I've been working for the last 3 months, yeah, almost 3 months. I've only received 3 paychecks because they ended up holding, the first one for like, it was like a 3-week rollover. I get paid once every week.
Yep.
So do you work at all in the month of January?
Yeah, of course.
When?
I never read one of these, bear with me, it's like, pay begin date, I don't have the exact dates I worked, but it says, okay, it's 11/29, this is 1/10 through 1/30. I wish I had some more.
110 through 130?
Yes, Your Honor.
How many hours does it show?
57.
Okay, so you could work January 10th through January 30th, but not test.
I only missed like 3 days of work because of my days off kind of rolling around with it, but also, Your Honor, like I said, there was a 7-day period for 7 days, no colors come up. I don't know if we can get proof of that or not, but that's honestly our truth. Luckily, it was while I was sick, so.
Mr. Barker, any questions before I go to Mr. Bahani?
No, Your Honor.
Ms. Alencar, isn't it true that you're on bond to the 52nd Circuit Court for 7 felony controlled substance charges? It's a yes or no question.
I'm not sure how many there is, but I mean.
Is it fair to say that you are
I
on
believe
bond to
so.
this court
I
for
believe so,
several
sir.
controlled substance felonies?
Yes, allegedly.
Correct. You've been charged, you've not been convicted, correct?
Correct, sir.
A condition of your bond is that you submit to random drug and alcohol testing, isn't that true?
Yes, sir.
A condition of your bond is that you comply with GPS tether monitoring, isn't that true?
Yes, sir.
Is it fair to say that you did not comply with GPS tether monitoring by allowing your tether to lose its charge and turn off?
Like I said, sir, I wasn't
That's a yes or no
aware, I
question,
wasn't
ma'am.
aware of that. I was asleep.
That's a yes or no question.
What was the question? I'm sorry.
Isn't it true that you failed to comply with GPS tether monitoring
I-
by allowing your tether to lose its charge and turn off?
I
Yes or
would
no?
say, I would say no, sir, because I wasn't aware of it.
Thank you. Isn't it true that you failed to comply with testing by missing 6 tests on January 2nd, 6th, 7th, 12th, 17th, and 20th?
Yes,
Isn't it true that you worked at your job during the period of January 10th through January 30th for 57 hours?
no, I'm not exactly sure how to read these, and I'm not exactly sure what the dates are.
Isn't it true that you worked for any period of time during the time of January 10th to January 30th?
Yes, sir, but like I said, there were
I have
7
nothing
days.
further on.
Your Honor. May I-
No, Mr. Barker, do you have any other follow-up questions?
Ms. Alencar, at any point, did you make a conscious decision to just ignore your conditions?
Absolutely not, Mr. Barker.
Have you complied to the best of your ability?
Yes.
Now,
Since sorry.
the judge's concern obviously is that when you were saying you were ill and weren't able to test, that apparently you were employed, but were you, it's obviously when I say employed, you're an employee of Taco Bell, but were you actually showing up for your work days, or did you have to miss work?
I missed 3 days of work. And there was a 7-day period. During this time, there was no colors being called. So for that week, that was part of the week I was sick.
Okay, are any
I
of those?
haven't dropped dirty at all since I've been out. I've never missed one until I got sick. And then Yeah, and I've been working the whole time. Or
So-
full time. I just had to get out of that wedge of financial burdens.
Are you aware of any of these dates that they're listing of that, that you missed as a date when you checked and there was no, your color was not called?
I'm sorry?
On any of these dates that they listed here, there's,
Yeah.
6 of them. Were any of those dates ones where you checked and your color was not called? That you're aware of?
I guess I'm confused on the question, Mr. Berger. I'm sorry.
Okay. Were you checking every day? to see if
Yes,
your color
every
was
single
called?
day. I did, even when I was
Okay.
sick.
So
Yes.
even when you were sick, did you make a note of the dates that you checked, and your color was called and you weren't able to go?
No, I was so sick. I wish I would have now. I wish I
Okay.
could get a list of them.
You said-
And I apologize for that.
Okay, you said you were in contact with Miss Wood
Yes.
about these things. Did you call her or talk to her about these dates that you missed?
Yes. I talk to her every Wednesday, so yes.
Okay, so you would not necessarily call her the day after you missed or the day that you did miss, but you would talk to her about it on your next scheduled day with her? Is that
Yes.
what you were doing?
Yes, sir.
Okay.
And
Do you understand that the appropriate thing would have been to call her immediately and let her know there's a problem?
actually, no, I think I did call her when I was sick. During the time I was sick, I believe I did call her. Maybe once or even twice.
But that's out of 6 dates. So,
6 days.
but only, so once or twice you talked to her about it.
Oh, so more than that, like 3 or 4 actually. Because I talked to her last week and that's when, last Wednesday, and that's when she said she said she had got an email from J&H. Man, my mouth is so dry. I can barely talk. I'm sorry. Anyway, she said she got an email from J&H about me missing, so she was gonna have to send something over to the prosecutor's office.
So if
And it kind of caught me off guard because she told me just to make sure I get to my next ones.
okay.
And then within a couple hours, I had a date for
So when is the last time you tested?
tested. It's been a while.
Okay. If the
But,
court, if the court tests you today, are you going to test
Yeah.
clean?
Of course. And also the colors haven't been called the last 3 days neither. I call every day.
Okay. But if the court tests you today, you would be clean. Or
Yes,
let's
sir.
say you will be clean. Okay.
Yes, sir.
Okay.
That's-
And if the court decided to remand you to jail for a couple of days, something, would that cost you your employment?
Yeah, I was supposed to be at work at 7 tonight. Whether or not it would or not, I would have to speak to them, but, I'm supposed to be there at 7 tonight. I have my schedule here.
So it would be a risk.
Yes, definitely.
Okay. Your Honor, I have nothing further for her.
So,
Anything else, Mr. Bond?
Your Honor, people call Jamie Wood to the stand.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Good morning, ma'am. Can you please state your name for the record and spell your last name for the court reporter?
Jamie Wood, W-O-O-D,
Ms. Wood, how are you employed?
the pretrial service officer.
As your role, in your role as the pretrial services officer, do you supervise Amanda Shea Loncar?
Yes.
Is it a condition of Ms. Loncar's bond that she report for random alcohol and drug screens?
Yes.
Is it a condition of Ms. Loncar's bond that she comply with the use of a GPS tether?
Yes.
At some point during the month of January, did it come to your attention that she was not complying with the random drug and alcohol screens? When did that happen?
Email from counseling on, say January 24th.
How many tests did J&A counseling indicate to you that Ms. Loncar had missed?
6 tests.
During those those, and would that be the dates that were included in your bond violation report that's attached to the people's motion as Exhibit 1?
Correct.
During those dates, which start on January 2nd and end on January 20th, did the defendant ever contact you to advise you that she was going to miss tests?
No, she did not.
Did she ever call you to advise you that she was sick with COVID during those dates?
She contacted me and I talked to her on January 17th. She said that she had COVID prior to that date.
So your first contact with Ms. Loncar was on January 17th.
Correct, according to my notes.
Your
had
Honor?
left messages.
Your Honor, could I ask the witness to speak up slightly? I'm having trouble hearing her.
Sorry. She had left messages almost every Wednesday. And so the previous Wednesday on the 8th, there was a voicemail from her and I tried to call her back on the 9th and didn't make contact with her. So the last time, the first time I heard about her having COVID was on the 17th.
And is it correct that she also missed a test on the 17th of January?
Correct.
Now, did it come to your attention at some point during the month of January that the defendant failed to comply with the use of her GPS tether?
Correct.
And on what date was that?
That was on Friday, January 26th.
And did you receive a report or email or a telephone call from the tether company that indicated the same?
Correct. They sent me an email stating that the defendant allowed her GPS tether to shut down on January 26th at 7:41 a.m.
And at what point or in what date did the GPS tether return to service?
That same date, but not until, I believe it was 11 in the morning. I have to. So the shutdown cleared fully at 11:30 a.m. that same day, January 26th.
Did the defendant ever provide you with an explanation as to why her tether failed to function on that date?
She had advised that she thought it had been plugged in, but may have come unattached when she was sleeping.
Whose responsibility in pretrial services is it to maintain the proper charge of the tether?
The defendant's.
Whose responsibility when a defendant is on pretrial release is it to comply with the testing, random testing of drug and alcohol screens with any agency?
The defendant.
Thank you. I have no further questions for Ms. Wood.
Thank you. Mr. Barker, cross-examination.
Ms. Wood, are you aware of any failed tests by Ms. Loncar?
No, I'm not.
The tests she has made, they were all clean?
Correct. The last test that
Okay.
she had completed on 12/28.
Do you have any other information indicating that she is using drugs or alcohol when she's not supposed to?
No indication because there was no testing in January.
No, but you haven't heard, I mean, it's a small town, you haven't heard any gossip or anything that would indicate she's not doing what she's supposed to?
The defendant's not in this small town. She's in another county.
Okay, withdrawn, Your Honor.
Pardon me, you withdraw.
I said withdraw that particular question. Yes, Your Honor.
Yep. Thank you.
Ms. Wood, would you consider her overall attitude in dealing with you as being cooperative?
I have had a few discussions with her regarding testing and where she was arguing about where to go test. So I would say, no, she hasn't been totally cooperative.
Oh, and I didn't ask her if she's total. I asked her if she was largely cooperative. I mean, she's been out for a while.
Largely, no.
At this point, do you think with a stern warning from the court that she is likely to continue to successfully follow her bond conditions? That she's got in the right mental place for that?
Objection, that calls for speculation.
Response, Mr. Barker?
Okay, I withdraw the question, Your Honor. Ms. Wood, what would you say? Would it be appropriate, perhaps, because of her financial situation, and because all her tests that she's taken have been clean, to perhaps lower the number of tests or move her to a testing facility that's closer to her work in the home area to help cut down on the costs and time involved in getting to the tests? Would you have an objection to that?
I would, because the reason I chose that testing place is because they are easier to communicate with. I do realize that they are, I believe it's $10 more per test, but they have a different system where I can actually log in and see the results, and usually can get those quicker than the other place they require. I map quested both facilities, and they are within 1 minute distance wise from her residence. So I picked the one that's easier to deal with.
Okay, taking into consideration that answer, and considering that it is random testing, would random testing less frequently be perhaps appropriate due to the financial burdens of it? I mean, if she still doesn't know when the test is coming, she would still have to stay clean. So would that be something that might make her cooperation easier under her circumstances?
Correct. I usually take those into consideration. If somebody has been on bond and they haven't tested positive in a few months, I will sometimes lower that based on their circumstances. But prior to release, she was notified that she would have random testing, and to make sure that she was able to pay for that if she bonded out.
Understood. I have nothing further for the witness, Your Honor.
Okay, thank you. I only have one question. Any testing?
Not that I'm aware of.
Do you have any follow-up?
No, Your Honor.
You may say. Any further proofs?
No further proofs, Your Honor.
Any other proofs you want to present, Mr. Parker?
No, Your Honor.
Your Honor, if the court recalls, back at the time the bond was modified to grant the defendant a personal recognizance bond, defense counsel argued that she didn't need any kind of drug testing at all. That the court decided that that was not accurate, that the bond as it was set at the beginning by the district court for random testing needed to be included. Now, here we are again at a bond violation hearing, and we're hearing how difficult and how challenging it is for this defendant to participate in random drug screens, which is her responsibility as part of the privilege of pretrial release. She is charged with 7 controlled substance felonies. This is not a property crime or a driving crime where use of controlled substances or alcohol may not be as large of a factor. In fact, the very root of each of these 7 cases is the use and delivery of controlled substances. The whole point that this court has ordered random testing. The fact that she does not live in Huron County any longer is the reason that she's on a GPS tether, the reason that her location needs to be monitored 24 hours a day, 7 days a week, and that is also her responsibility. It was explained to her at the jail before she was released on bond, and she agreed to the conditions of bond. The responsibility lies with the defendant here. She's admitted that she has not been in compliance with bond and gives the court many reasons, but the reasons don't seem to add up, because she says for 18 days she couldn't test, but for at least part of those days, based upon her own testimony and the pay stub that she's presented from January 10 through January 30, she worked 57 hours. So during that back 20 days of the month of January, she was able to work, but she still couldn't go in to test. And then we hear the arguments about it's financial. Well, Your Honor, it's necessary. because of the exact nature of these charges that she must constantly be monitored on pretrial release. The fact that she has not complied with that, Your Honor, deserves sanction, and the people are seeking revocation of her bond.
Yes,
I
and
read these incorrectly. I'm not sure. This is my first time ever reading pay stubs. I read these incorrectly. If you would like to look at them, Your Honor. Maybe.
No, court's heard enough. I'd like to hear from you.
Oh, sorry.
I'm sorry. In response, Your Honor, she is a young woman who is, obviously the charges that are pending, has made mistakes in the past, is trying her darndest to show the court that she has reformed herself. She is the sole care of her grandmother, who has to have somebody carrying her, and she's doing that. She's trying to keep up with the work. They did have the COVID situation, and 57 hours in 20 days works out, like 3 hours a day. However, we know nobody's working 3-hour shifts each day. So she missed, we don't know that the dates that she didn't test were days that she did go to work or was able to go to work. We don't have anything in front of us showing the correlation between those two things. And my understanding from talking to her is that, she did not miss testing on a date when she actually worked. So that argument is, I won't say specious, but it's weak on behalf of the people. She does seem to be trying, obviously, if she were a first-class super citizen, we would never have been in this situation to begin with, but she's trying to get there, Your Honor. And she's a young woman who's, in poor circumstances, be they of her own making up until now, but she is trying to do things. I think if the court allows her to continue, that she certainly understands now that she has to be exactly spot on with everything. And due to the circumstances being what they are, and her grandmother, and the fact that she has maintained employment, she has not attempted to flee, she has not had picked up any more charges or police contacts, I would ask the court to allow her to apologize and to do better.
Thank you. Court's heard the respective arguments of counsel. The court has also heard the explanation by the defendant. The court has also heard the testimony of the pretrial services worker. And there's a saying, it don't add up. It just doesn't add up because there's no testing at all in January. December 28th was the very last test administered. Nothing in January, nothing in February, 56 hours, 57, somewhere in there that the defendant has worked. It's her responsibility regarding the charging of the tether. That's the benefit of not being under a $10,000 cash surety bond, which was previously offered in this case. I find that the defendant has violated the terms and conditions of her bond in this case. And rather than find her in contempt, the court is going to modify the bond. Same conditions apply, however, now it will be $10,000, 10%. Must be posted for the defendant's release. All prior orders remain in effect as otherwise stated. And Ms. Loncar, if you're able to post that bond, you have to be contacting or following through with the testing. You need to make sure your tether is charged. You need to stay in contact with Ms. Wood. Ms. Woodford has testified that other than some of the Wednesdays you called, you didn't call her, as you stated you did it. So I'm amending the bond. That is the final order of the court relative to this issue.
I'd like to apologize at first as well.
I accept your apology.
I never meant to violate your ruling at all, Your Honor. And there was several phone calls. Okay. No, there was several phone calls back. Remember you said we were going back and forth playing tag?
We're not arguing about
Oh, no, I'm not arguing, Your
the
Honor.
court made its ruling. That'll conclude the procedure.
Your Honor,
Thank you.
Your Honor.
Yes.
Yes. Could she have a week or so to raise the bond before she surrenders herself?
No. No, not, we've had radio silence on testing the whole month of January and starting in February.
Thank you so much for watching tonight, and I'll see you next time.